Jane and I did a very similar problem, and I don't know how to create a website.
Oh,
so I would love to do that. It's amazing.
You can easily do it, and you can do it on PowerPoint.
Are you kidding?
Yeah, you can create a little mock website just by importing PowerPoint images and using the little the text compartments that PowerPoint gives you. And when I was in China, I did it that way. For the press release, I used PowerPoint. For the website, for the various pages on the website, I just used PowerPoint slides.
How do you do the interactive form? Because that was really a big problem.
Do you mean actually clicking something?
Yeah.
Okay, so I mean, I did it with my own web design experience,
Yeah.
but you can. There are website design softwares that are free and that are online. One is called Wix.com, Wix.com. And it's a basic drag and drop software where you can create a contact form, where you can do this. And I did that for part of this. I used part of Wix for this, and then you could potentially upload the website.
What was the student reaction to using the website? And
they were thrilled by it. I think. I think I heard a lot of comparison between sections. Like, you have a website, you're doing this. We got a fact pattern.
Yeah,
I mean, and that's not the type of reaction that I'm trying to elicit. But I think it really did drive a discussion about factual relevance, more so than it would have with a fact pattern.
That's fantastic.
Mm-hmm.
No,
I had a similar question because I've done an internet personal jurisdiction also based on an Aryan youth group whose teachings ultimately resulted in the death of a gay teenager. But I did deposition transcripts to elicit a fact pattern, so that it's not quite receiving the fact pattern. So I'm wondering if you have any other also means apart from, because I don't know how to design a website.
No, yeah, we just did a fact pattern.
We did interviews.
Yeah, interviews and stuff like that. Interviews with the person who created the website, but
one of the
website would have been so great.
Well, the follow-up memo, the supplemental memo, was an interview with the CEO of the company, a telephone interview, and it talked about more specifics about the live help feature.
Right.
So it was more of a narrative of what the website can do.
You would have both.
Yeah.
Right.
Yes.
Could you use a real website? I mean, if it were an objective,
Absolutely.
If it were an objective problem and it didn't have to be split fairly among your students.
Absolutely. I incorporated a little YouTube here. You could actually you could actually have students visit web pages that are already online that you have a profile, that you've created a profile on, for example, YouTube. And so they actually go to the live YouTube website where they see where they gather information, and maybe they go to another website where they gather more information. So you could do that. I don't see any problem with, for the purpose of, education, sending them to a real website and having them garnish the facts from them. And be much easier, probably.
You just have to hope it stays the same.
That's right. That is one important thing. So a good thing about creating profiles like Facebook profile or like Twitter profile and putting up Twitter posts is that you can have some control over the information, how long it stays up there.
It's hidden over here. For actually both you and Tracy, do you reuse the same problem year after year, or do you have to recreate something brand new after
No, I
time?
reuse it.
So you just take that binder of facts and fix it, update it a little bit?
Yeah.
How about you? Can you reuse?
And all my colleagues do.
I've reused both of them before, but I've sort of templatized the website. So I can change around. Last year it was a coffee plantation that was located in Indonesia. So I do change around the party names, the basic premise, but the law pretty much will stay the same. Now, I do have to caution with internet personal jurisdiction, there's a lot of flux in the law. So each year that you do use it, you have to really update your cases.
I was curious about the supplemental file aspect of your assignments. My impression is that you basically decide what information is going to be in that. So I just wanted to see if in fact that is true, but I was also wondering if you've ever incorporated a discovery aspect into it where between the initial presentation and the supplemental file, students could submit questions to you.
That is exactly how this example 2 worked, essentially. I did have an idea of a couple things that I wanted to tell them, but they after they did their entire open memo research, the initial round, they came back with a research result, research log, and at the end of it, I had them ask, I have a list of questions of facts you'd like to know, essentially, follow-up things that you'd like to ask the client or the other side. And I looked through those and I sort of picked the interesting ones and gave reply.
Do you have to assemble permissions for any of the visual effects on the website?
For this website, I chose public domain images. I chose images like the black and white images from the Library of Congress photo archive. The second one is a public domain image, and I do believe on the website it's credited to Flickr Creative Commons on Flickr. So you can actually use, if you go to Flickr and you look at you do an advanced search for Creative Commons licensed photos, all you have to do is cite the username for the credit. But one of my favorite things is going to the Library of Congress public domain photos and just taking those photos.
I like the idea of an audio file of an interview. It seemed very realistic. But I find myself wondering, what does it add pedagogically that a transcript of an interview would not?
I think, well, I'm very concerned about starting the simulation day one and initiating them into the law firm day one and giving them a first assignment that is very similar to a first assignment that they get, which is to listen and write rather than type, rather than read a transcript. I think that it gets them off the page pedagogically. I think that that is a benefit. It gets them engaged right away. And I think there's plenty of time, and I do introduce transcripts second semester and later on in the semester. So I like to give it a little variety, like at the get-go.
I actually had a question for Lee. Is there any way, do you debrief with the students after the speed dating? Like, is there any way you do quality control?
Well, I do circulate among while it's happening. And so, for example, so sometimes, two people might both be stuck. Like if neither person knew how to distinguish, because they had both sort of found that this case was so similar to Farabee, they could really be stuck. And so I could then offer a little bit of guidance to get them going. But so it's more live. I have not done a sort of a whole class debriefing of the sessions.
Question for Lee.
Yes.
Do your materials include sample questions, the type that you've used in past speed?
The PowerPoint does not. They really are tailored to specifically whatever problem I'm trying to address. So for example, I've only used this twice, and the first time I simply had a case name because I wanted them to do what's the case about. Is it good for us or bad for us and why? And then the second time I just tailored it so that they would have to start to think about the other side, for both sides. So no, I mean I could show you my specific questions, but they really do relate specifically to my problem. Very short, just write it on a note card, one simple question.
Lee, do you think your speed dating would work for in an exercise where students were asked to very quickly communicate sort of the substance of the law to a lay client?
That's a great idea.
Because I find that one of the hardest things, and somebody mentioned it in an earlier presentation, one of the hardest things for students to learn is how to counsel their client about what the law says in a way that is clear, concise, and in terms that a non-lawyer can understand. And I'm thinking maybe in this speed dating format, that would be something that they would be required to do. And I'm trying to decide whether to do it before or after they actually have to counsel the client. But I just wondered if
I'm
that
just
made
thinking
sense.
about how helpful that would be to prep them for the client letter, down the road, and then to have that person give real feedback. Obviously they come with the knowledge of the lawyer, having studied the same case, but they can put themselves in the shoes of the client and say, well, I don't know what you meant when you said X. I like that idea, yeah.
I just had a couple of quick comments for Tracy. One was with regard to using a motion, and particularly a summary judgment motion for the persuasive value. We had been using an appellate brief, and we just kept getting barraged with feedback from alums saying, stop teaching the appellate brief in first year. It just doesn't help much. And so every time, now that we've switched over, we're getting all kinds of alums coming back to us saying, yay! And we've had very positive feedback about that. So I just thought you might be interested in that.
And the most we interact with our alums is around our appellate advocacy semester.
Yeah.
So that and so we hear about that and preserving that. So that's nice to hear.
The main stonewalling we ran up against a little bit was from our moot court programs.
Right.
Because they said it's going to delay, because now our students don't do it till third semester. Mm-hmm. But we basically said we're still teaching them all the persuasive stuff. So we didn't get, we're trying it out, but I think it's working okay. The other thing I was going to comment on is we've also run across the kind of, do they really understand summary judgment, and how does that fit in with the motion practice? And we're still playing around with this, but actually one of the Civ Pro profs is going to come into some of the legal writing classes this coming semester, and I think he views it as helpful for him too, because he can be connected to how they get the assignment in the legal writing class, and then when he is doing it more thoroughly in his Civ Pro class, he knows about the legal writing, and they've already heard from him a little bit about it in the legal writing context. Yeah. So that kind of interaction, I'm very excited about. We're trying it for the first time, so we haven't actually done it yet, but I could see this as being something that could work really nicely, I think.
Yeah, thank you, especially since I have this colleague with whom I co-teach a class. I never even thought of having her come in. It's a great idea. In our first semester with the Legal Writing 1 program, we've just done that in 2 different ways, with contract and tort. Having the professors come in, and so in torts I came in and taught the Legal Writing 1 students, and then in contracts they actually took that Legal Writing 1 problem and used it in their contracts class. So that kind of crossover is great. Brian, were you going to add something about alums?
That I've had a little bit of feedback from some students who have gone out to summer clerkships, and the partners for whom they worked were very pleasantly surprised that they knew how to write a motion for summary judgment. So,
and I should say too, I think that going along with that, my students will often use that as a writing sample.
Absolutely.
And so their audience really understands it. Where with the brief or even a law review note, you're cutting it down so much. It's hard to really show your legal analysis skills as clearly. Suzanne, and then Jane. Right, Jane?
Yes.
And then Lisa. Suzanne, you get to be
questions for you, Tracy.
Oh,
just in terms of the logistics on the summary judgment, do you have the students submit the memorandum of support and then the other students submit the opposition motion, or do you have a simultaneous filing? How do you do it?
We do simultaneous. Oh, well, actually, I think each of us does it a little differently. I do it simultaneously. So we suspend some real world stuff there. But yep.
And then do the students argue the motion?
They do. Yep, and I was just mentioning in the earlier session in the room over there on oral advocacy. So the students do a short argument. It's only about 10 minutes per side. They also have a practice, but I also videotape. My high-tech thing is to have a flip camera now. And for $100, this is like revolutionized my life. And what's great is that then we post them on a secure spot on our web. Students view them, I give them debriefing questions, and then they reflect and write a memo on it, which is nice preparation for the third semester with appellate advocacy, where they have a longer argument at nighttime in front of, practicing lawyers and judges. So it's good prep work.
Do they write the motion itself, or only the memorandum?
I give them the motion. My colleague Hillary has them draft the motion, and my colleague Tony, I think, gives them the motion. But so to give, one has them draft, do the mechanics of it, but then they all write the memorandum, and that's what I focus on, is the memorandum. Thanks.
Yeah, I just had the observation that this question of whether to drop the appellate brief from the first year legal writing curriculum and adopt something more realistic in terms of legal practice, which I fully applaud, illustrates one of the things that we're up against in changing our legal writing curriculum to be more reflective of modern day practice, and that is that we've got these traditions in the law school And the law school has bought into appellate advocacy as part of the law school culture. The whole moot court phenomenon and all that involves, which often is a wonderful experience for students, gets the school's name out there.
Gets your alum involved.
Gets your alums involved. And so that exerts some pressure on us to teach appellate advocacy.
Yeah.
So, and similarly, I sometimes think when we're teaching a memorandum that involves a multi-element tort, we're really teaching exam writing skills, not so much law practice writing skills. So when we take these first-year law students, their immediate practice environment is law school. And, you know, a little further down the line, their summer employment or internships. And we've got conflicting needs there. What do you teach them so they do well in law school? As opposed to what do you teach them so that they're prepared for practice?
Yeah. Yeah, I have to say, I'm so lucky because I get to have my cake and eat it too. You know, so we have the third semester that's required, but I'm hearing about all the programs where there's an appellate advocacy elective offered.
Right.
So that's still out there. And I won't be surprised. I mean, we talk about it pretty much every year and get serious about talking about every 2 years of changing that third semester curriculum to still be a required writing course, but to let students choose to do appellate advocacy versus some type of transactional or admin law, something more oriented, because our environmental law students are very focused on you know, working before ALJs, for example. So I hear what you're saying. I love the fact that so many programs still have appellate advocacy and that it's so many students want to do it, but that it's not required. That seems to me maybe a middle ground.
Ours is not required, but it seems to be expected of the first-year legal writing course. So you can take an elective in appellate advocacy, and you don't have to study appellate advocacy at the upper level.
Got it.
But as part of our course, it's an appellate brief that you're supposed to get them to do, and it's an appellate argument that you're supposed to get them to practice their oral skills in. And that seems to me not reflective of practice, but very reflective of the law school
the culture
and expectation.
Yeah.
Lisa?
So I have a quick question, but I just wanted to say first, I don't think I've ever heard so many questions in a last session.
Listening to those people eating cookies out there.
What I wanted to say is obvious that your presentations are excellent and really useful, so thank you.
Thank you.
But my question is for Lee, just quickly. So I'm thinking about, I used speed dating this fall and did it a little bit differently thanks to you, but with the questions about the cases, do you think that they would be ready for that for a first draft? Because my frustration is that I don't think they learn the cases until the night before the first draft is due. Well, not always, but sometimes. So in the spring, what do you think about that? Is it you said you do it between the draft and the rewrite, right?
When it's simply the case itself, is the case good for us, bad for us, or?
Yeah, exactly. So
that was
just
before the first draft.
Oh, okay.
No, because they really, and it also allowed them to see, especially since they were paired up with someone from the other side, why someone else thought this case was helpful for them.
Okay, so you
So
did that before.
I did, yeah.
I think that's really cool.
I'm sorry, I know Lisa said we should go, but I
Oh, no, I didn't mean it that way. I just meant
two things. One, at Northeastern, we only do a motion to dismiss and a motion for summary judgment in the spring. We do not do appellate. I teach in the advanced class, and I do an appellate brief in the advanced class, and they have the appellate advocacy. Also, we do run into that little bit of like law students, like, what do you mean we're not writing an appellate brief?
Yeah.
I think
What's wrong with us?
I think the problem is that the thought is that the appellate briefs generally tend to involve weightier issues, constitutional issues that might not come up on the motion for summary judgment, obviously not for motion for summary judgment. So I think that that's the whole notion that it's much more meaty doctrinally, and that's why they want it.
Right.
And then I have to, in my advanced class, slam through an appellate brief in 2 weeks. We have 2 weeks to write it. Done. Yeah, I'm kind of mean, actually. But my question actually went to Lee, which was, the speed dating is such a great idea, and I'm curious about it for my peer editing, because I'm very anxious always about peer editing. I like what you said about how they'll hear it from multiple audiences, but do they get the paper right then and have to read it and comment on it right then.
Yes, but it's what so I myself have not used it for peer editing, but my colleagues who have, Lisa, was that what you used it for or no?
So I did it twice. I did it because they liked it so much I did it again. The first time I put a question at each station about some substantive issue of the law, reasoning from a case, or one of the prongs of a test. And then I did do it for peer editing, and I just did not set it up well because they didn't have. I didn't want them to exchange things beforehand. It was before it was due. I didn't want them leaving the room with anything. So I think my recommendation would be, if you're going to do that, it has to be something very specific. Like station 1 is the topic's thesis sentence for the first explanation paragraph, or the rule for causal connection, or they're looking at like one sentence.
The two other, that's helpful.
Otherwise, they have to have the reading time before they sit down.
Application.
And I think the two other examples that were shared with me were a question presented and a statement of the issues. That's a real simple thing, and I actually, whenever you do any type of peer review, I think it's important to have everyone submit to you what they're sharing, and that allegedly they think that therefore they can't steal from one another. I mean, not that I'm really going to go spot check every single one, but that makes them feel more comfortable about sharing their work with someone else. Again, no one has computers and whatnot, so they're not going to copy down each other's work. With 5 minutes going, it's I don't think they're going to memorize and take from someone else. But it does have to be a very short piece.
Can I just ask one more question about the speed dating? So tell me why the Smith case is analogous or not, and then the other person does the same thing. Is that how it works?
That's a good question. So for that particular one, yes. So the other person for that example, I actually only one side would have the challenge, the other would give feedback, and then they would shift.
I see.
Because that would just be too repetitive.
Right, exactly.
Yes. Okay. So it's only when you've got plaintiff and defendant that it really is useful for both sides to.
Thank you.
Sure.
I was just thinking with the statement of the case, even though I don't like to bifurcate it, sentence by sentence, I could imagine, although maybe you want to do it last or first, but you could essentially in the speed dating stations model what you do when you're critiquing. So someone on the statement of the case could say overall organizational structure. And that's a skim through looking at headings and have you. Next one could be focused on that intro paragraph. Have you begun with a punch? Another one could be on juxtapositions. Read this section and find you've seen some persuasive factual juxtapositions. Another one could be on citations. That just occurred to me. Sure. I love this speed dating idea. Someone who's been married for over 25 years. I mean, this is great.
The students get really silly, but they like it.
I could see that. Yeah.
I just have a question for Lee too. Do you do the one where you have them do the cases? Is that on a closed universe?
It's actually not. So you have to think carefully about what would be, what I call 6 core cases. I mean, these are cases that both sides would have had to have read and been familiar with. And cases we've discussed in class. I mean, clearly they're going to both be using some other cases as well.
Thank you.
Thank you.
Fill out your evaluation